Good morning, honorable judges of the African Court on Human and People's Rights. Good morning, registrar, staff of the registry, interpreters, and members of the public who are observing these proceedings, and of course the parties to the various cases whose judgments we shall be delivering this morning. The court will be delivering 8 judgments, and they'll be read by different judges of the African Court. And because of the time that is required to go through all the judgments, and many of them are quite long, we are only going to be reading certain sections of the judgments. And those who wish to understand or get more details about the judgments will then be able to look at the final judgments once they are issued by the court later today or on Monday. With that, I would like to give the floor to Dr. Robert Eno, the Registrar of the African Court. Dr. Eno, you have the floor.
Thank you, Honorable President, Honorable Judges. Honorable President, this is the sitting of the court for the delivery of judgment. The bench as composed is going to deliver judgment in respect of the following matters. Application 011 of 2015, Christopher Jonas against the United Republic of Tanzania. Application 033 of 2015, James Wanjara and others against the United Republic of Tanzania. Application 010 of 2016, Hamad Mohamed Lyambaka against the United Republic of Tanzania. Application 039 of 2016, Chananja Luchagula against the United Republic of Tanzania. And application 019 of 2019, Job Mlama and others against the United Republic of Tanzania. Honorable President, all the parties, the respondent and the applicants have been duly notified of the delivery of this judgment. I thank you, sir.
Yeah, thank you very much, Registrar. Let me indicate that apart from the 8 judgments that are going to be read, the court at this session has also issued a number of rulings and orders, but those ones will not be read in court, but will be issued directly to the parties and will be posted on the website of the court, as for these judgments, as will be done with these judgments of the court. I will start by reading the first judgment, which is application number 011 of 2015 in the matter of Christopher Jonas versus United Republic of Tanzania, application number 011 of 2015, judgment reparations. The court composed of Sylvain Ore, President, Ben Kioko, Vice President, Rafa Benashu, Angelo V. Matusse, Madame Therese Mukamu, Chafika Bensaoula, Blaise Chikaya, Stella I. Anukam, in accordance with Article 22 of the Protocol on the African Charter on Human and People's Rights, on the establishment of an African Court and People, the Protocol, rules of court, the rules, Justice Imani D. Aboud a national of Tanzania, did not hear the matter. In terms of Jonas, represented by Advocate for Pan-African Lawyers Union, and the Republic of Tanzania is represented by the Solicitor General, Dr. J. Mashamba, and a number of other the present. The present request for reparations filed on 11th October 2018 arises from the judgment on the merits dated 28 September 2017, in which the court found that the United Republic of Tanzania had failed to provide the applicant with a violated Article 71C of the African Charter on Human and People's Rights for failing to assist. Brief background that is right. Information on the proceedings and to legal representation, being convicted on the basis of uncorroborated testimonies, and being subjected to a sentence that was not applicable at the time of the trial. In the said, the act is to 30 years imprisonment for armed robbery. The judge 6, 9, and 10 reads as follows. That the respondent violated Article 71C of the Charter in terms of the applicant's allegation that he did not, and the state also one of the Charter. Paragraph 10. Of receipt of this judgment, also requests the respondent state to submit its response on reparations within 30 days of receipt of the applicant's brief. That serves as the basis for present request for reparations. I now go to the prayers of the parties. The applicant prays the court to grant him the following reparations. 1, the amount of $185,000 to Christopher Jonas as a direct victim for moral prejudice suffered. 2, the amount of $800,000 to Christopher Jonas for material prejudice suffered, or in the alternative, the amount of $36,640. 3, the amount of $30,000 to his mother and $20,000 to his siblings identified as indirect victims. 4, the amount of $65,000 in counsel's legal fees. 5, the amount of $2,000 for expenses incurred. I now skip the arguments of the court and go straight to the operative part. For these reasons, the court unanimously on pecuniary reparations does not grant the applicant's prayer for material damages due to his conviction and sentencing. 2, does not grant the applicant's prayer for damages for moral prejudice suffered by the indirect victims. 3, grants the applicant's prayer for damages for the moral prejudices suffered and awards him the sum of Tanzanian shillings 300,000. 4, orders the respondent state to pay the amount indicated under 3 above, free from taxes, effective 6 months from the date of notification of this judgment, failing which it will pay interest on arrears calculated on the basis of the applicable rate of the Central Bank of Tanzania throughout the period of delayed payment until the amount is fully paid. 5, on non-pecuniary reparations, does not grant the applicant's prayer regarding non-repetition of the violations. 6, does not grant the applicant's prayer regarding publication of the judgment. 6, on implementation and reporting, orders the respondent state to submit to this court within 6 months from the date of notification of the present judgment a report on the measures taken to implement the orders set forth herein, and thereafter every 6 months until the court considers that there has been full implementation thereof. On costs, does not grant the prayer related to payment of the legal fees, costs, and other expenses incurred in proceedings before this court. 9, decides that each party shall bear its own costs. This judgment is signed by the judges whose names I read out at the beginning of the reading of this judgment. Done at Arusha this 25th day of the month of September in the year 2020 in English and French, the English text being authoritative. And that is the judgment of the court. Now, Registrar, you can now read the next judgment. You can read you can indicate what will be the next judgment.
Thank you, Honorable President. Honorable President, the next judgment is application 033 of 2015, James Wanjara and others against the United Republic of Tanzania. Thank you.
Okay, thank you very much. This judgment of the court will be read by Honorable Justice Stella Anukam. Honorable Judge, you have the floor.
Thank you, Mr. President. The court is composed as earlier enumerated in the first judgment read by the President. In accordance with Article 22 of the Protocol to the African Charter on Human and People's Rights on the establishment of an African Court on Human and People's Rights, hereinafter referred to as the Protocol, and Rule 8(2) of the Rules of Court, hereinafter referred to as the Rules, Justice Imani D. Aboud, a member of the court and a national of Tanzania, did not hear the application. On representation, the applicants, James Wanjara and 4 others, are represented by Haniton Amor of the East Africa Law Society. The respondent, United Republic of Tanzania, is represented by Dr. Clement J. Mashaba, the Solicitor General of the Office of the Solicitor General, together with 6 others of the Attorney General's Chambers and the Foreign Affairs, East Africa and International Cooperation Office. The subject of the application. On the 31st of March 2001, the applicants, together with a co-accused who is not before the court, were arrested and charged with armed robbery and unlawfully causing grievous harm. On the 26th of October 2001, the District Court at Magu convicted and sentenced each of the applicants to 30 years imprisonment on the first count of armed robbery and 12 months imprisonment on the second count of unlawfully causing grievous bodily harm. The sentences were ordered to run concurrently. On the 5th of February 2002, the applicants, being dissatisfied with their conviction and sentence, appealed to the High Court of Tanzania at Woza, but their appeal was dismissed on 3rd June 2003. Subsequently, on the 13th of June 2003, the applicants appealed to the Court of Appeal of Tanzania, sitting at Wuza, which also dismissed their appeal on the 27th of February 2006. The record before the court confirms that the applicants attempted to trigger the process for review of the Court of Appeal's decision, even though no indication is given of the precise date when this was done. Nevertheless, on the 11th of March 2013 and subsequently on the 9th of May 2014, respectively, the Court of Appeal struck out the applicant's application for extension of time within which to file an application for review of his judgment, dismissing the applicant's appeal. Alleged violation. The applicants submit that the respondent state violated their basic rights as guaranteed under Article 1366C of its Constitution by imposing an improper sentence of 30 years imprisonment for the offense of armed robbery. The applicants also submit that the respondent state violated their rights as guaranteed under Article 1C of the Charter by failing to provide them with legal representation during the domestic proceedings. It is further contended that the evidence that was relied upon to convict the applicants was not well analyzed by both courts, and this default caused the applicants being convicted while the prosecution evidence was not sufficient to sustain their conviction. The prayers of the parties. The applicants pray the court to grant them free legal representation. 2, to intervene and quash both their conviction and sentence. 3, order reparation. And 4thly, to grant any other orders or reliefs as it may deem fit. The respondent states in return prays the court to grant the following orders with respect to the jurisdiction and admissibility of the application. 1, that the Honorable African Court on Human and People's Rights is not vested with jurisdiction to adjudicate the application. Secondly, that the application has not met the admissibility requirement stipulated under Rule 40 sub 5 of the Rules of Court and should be declared inadmissible. Thirdly, that the application has not met the admissibility requirement stipulated under Rules 40 sub 6 of the Rules of Court and should be declared inadmissible. Lastly, that cost of this application be borne by the applicants. The respondent state further prays the court to make the following orders on the merits of the application. 1, that the government of the United Republic of Tanzania is not in violation of the applicant's rights under Article 7 sub 1 sub C of the African Charter on Human and People's Rights. Secondly, that the government of the United Republic of Tanzania is not in violation of the applicant's rights stipulated under Article 13 sub 6 sub C of the Constitution of the United Republic of Tanzania, 1977. Thirdly, that the sentence of 30 years imprisonment for the offense of armed robbery is lawful. We will skip the argument in this case and go straight now to present to the public the operative part of this judgment. For these reasons, the court unanimously on jurisdiction dismisses the objection to his material jurisdiction, declares that it has jurisdiction. On admissibility, dismisses the objections on admissibility, declares that the application is admissible. On the merits, finds that the respondent state has not violated Article 7 of the Charter as regards the treatment of the evidence before the domestic courts during the applicant's trial. Also on merit, finds that the respondent state has not violated Article 7 sub 2 of the Charter as regards the applicant's sentence of 30 years imprisonment for armed robbery. The court further finds that the respondent state has violated the applicant's right to fair trial provided under Article 7 sub 1 sub C of the Charter, as read together with Article 14 sub 3 sub D of the ICCPR by failing to provide them with free legal assistance. On reparations, pecuniary reparation, the court does not grant the applicant's prayer for reparations arising from material loss of income and for legal costs incurred during the proceedings before the court. The court orders that the respondent state to pay each of the applicants the sum of Tanzania shillings 300,000 free from tax as fair compensation for a violation of their right to free legal assistance to be made within 6 months from the date of notification of this judgment, failing which it will be required to pay interest on arrears calculated on the basis of the applicable rates of the Central Bank of Tanzania throughout the period of the late payment until the amount is fully paid. The court does not grant the applicant's prayer for reparation for moral prejudice suffered by the alleged indirect victims. On non-pecuniary reparation, the court dismisses the applicant's prayer for release from prison. On implementation and reporting, the court orders the respondent state to submit to the court within 6 months of the date of notification of this judgment, a report on measures taken to implement the orders set forth herein, and thereafter, every 6 months until the court considers that there has been full implementation thereof. On cost, the court orders each party to pay its own cost. This judgment is signed by the bench as earlier mentioned in the first case, and it is done at Arusha this 25th day of September in the year 2020 in English and French, the English text being authoritative. This is the judgment of the court in this case. Thank you.
Yeah, thank you very much, Honorable Justice Stella Anukam. That will be the judgment of the court. I now give the floor to the registrar to call out the next matter.
Thank you, Honorable President. Honorable President, the next matter is application 010 of 2016, Hamad Mohamed Lyambaka versus the United Republic of Tanzania. I thank you, sir.
Thank you very much. The judgment of the court will be read by Honorable Justice Tujilane Chizumila. Honorable Judge, you have the floor.
Thank you, Honorable President. The matter of Hamad Mohamed Lyambaka versus United Republic of Tanzania, application number 010 of 2016 ruling. The court is composed of the same bench as the previous two judgments. And in accordance with Article 22 of the Protocol to the African Charter on Human and People's Rights on the establishment of an African Court on Human and People's Rights, hereinafter referred to as the Protocol, and Rule 8.2 of the Rules of Court, herein referred to as the Rules, Justice Imani D. Aboud, a national of Tanzania, did not hear the application. In the matter of Hamad Mohamed Lyambaka, who is self-represented, versus United Republic of Tanzania, represented by Dr. Clement Mashamba, the Solicitor General, and 5 others from the Office of the Attorney General's Chambers and the Ministry of Foreign Affairs, East Africa, Regional and International Affairs. After deliberation, renders the following ruling. Facts of the matter. The application arises from the applicant's conviction jointly and together with 4 other defendants for the offenses of armed robbery and gang rape, for which the District Court of Musoma sentenced him to 30 years in prison and life imprisonment respectively by a judgment delivered on 16 July 2002 in criminal case number 35 of 2001. Aggrieved by the decision of the District Court, the applicant filed a criminal appeal number 05 of 2003 before the High Court of Tanzania, sitting at Mwanza, which in a judgment dated 2 July 2004, dismissed his claims. He further then appealed the judgment of the High Court before the Court of Appeal, sitting at Mwanza, in criminal appeal number 178 of 2004. On 16 March 2007, the Court of Appeal dismissed the applicant's appeal. The alleged violations: the applicant alleges that 1, the judgment of the Court of Appeal was erroneous, as the court did not sufficiently evaluate the evidence presented before the prosecution. 2, that the Court of Appeal did not consider all grounds of appeal raised by the applicant and thus violated his fundamental right to be heard by a court of law. And thirdly, that his right to legal representation was violated as the respondent state failed to accord him legal representation. Prayers of the parties: the applicant prays the court to make the following findings with respect to its jurisdiction and the admissibility of the application. That the court has jurisdiction to examine the application, and that the application has met the admissibility requirements as stipulated under Article 56 of the Charter, Article 6.2 of the Protocol, and Rule 46 of the Rules of the Court. With respect to the merits of the application, the applicant prays the court to 1, declare that the respondent state violated Articles 2, 3.1 and 2, and 7.1c of the Charter. 2, declare that the respondent state violated Articles 1 and 107A2 of its Constitution. 3, restore justice where it was overlooked and quash both his conviction and sentence imposed on him. 4, set him at liberty. 5, grant reparations in his favor. 6, declare that the costs of the application be borne by the respondent state. And 7, grant any other orders or reliefs as the court may deem fit. The respondent state makes the following prayers with respect to the jurisdiction of the court and admissibility of the application. 1, that the Honorable African Court on Human and People's Rights is not vested with jurisdiction to adjudicate over this application. 2, that the application has not met the admissibility requirements stipulated under Rule 45 of the Rules of Court or Article 56 and Article 6.2 of the Protocol. 3, that the application has not met the admissibility requirements stipulated under Rule 46 of the Rules and Article 6.2 of the Protocol. That the application be declared inadmissible. 5, that the application be dismissed in accordance to Rule 38 of the Rules of Court. And 6, that the costs of this application be borne by the applicant. With respect to the merits of the application, The respondent state praised the court to find that there is no need to pronounce itself. In the alternative, the respondent state praised the court to grant the following orders. 1, that the government of the United Republic of Tanzania did not violate Articles 2, 3.1, 3.2, 7.1c of the African Charter on Human and People's Rights. That the government of the United Republic of Tanzania did not contravene Articles 1 and 107A, 2, B of the Constitution of the United Republic of Tanzania. 3, that the application be dismissed for lack of merit. 4, that the applicant's prayers be dismissed. 5, that the applicant not be awarded reparations. And 6, that the costs of this application be borne by the applicant. I now move to the operative part. For these reasons, the court unanimously on jurisdiction, 1, dismisses the objection to its material jurisdiction. 2, declares that it has jurisdiction. On admissibility, 3, dismisses the objections based on non-exhaustion of local remedies. 4, finds that the application was not filed within a reasonable time, within the meaning of Article 56(6) of the Charter and Rule 46 of the rules. 5, declares that the application is inadmissible. On costs, 6, orders that each party shall bear its own costs. This judgment is signed by the judges of the names read out at the beginning of this judgment, and it is done at Arusha this 25th day of September in the year 2020 in English and French, the English text being authoritative. This is the judgment of the court.
Yeah, thank you very much, Honorable Justice Chizumila, for reading the judgment of the court. This is the judgment of the court. I now call on the registrar to indicate what will be the next matter to be read.
Thank you, Honorable President. Honorable President, the next matter to be read is application 039 of 2016, Chananja Luchagula versus the United Republic of Tanzania. Thank you, sir.
Yeah, the judgment of the court in this application will be read by Honorable Justice Chafika Bensaoula. Honorable Judge, you have the floor.
Thank you, Mr. President. The court is composed of the same branch as the previous judgment. In accordance with Article 22 of the Protocol to the African Charter of Human and People's Rights on the establishment of an African Court of Human and People's Rights, hereinafter referred to as the Protocol, and Rule 8 sub 2 of the Rules of Court, hereinafter referred to as the Rules, Justice Imani D. Aboud, member of the court and the National of Tanzania, did not hear the application. In the matter of Chananja Luchagula, self-represented versus United Republic of Tanzania, represented by Dr. Clement G. Mashamba, Solicitor General Office of the Solicitor General, and number of others representatives, after deliberation renders the following ruling. The parties, Mr. Chananja Luchagula, hereinafter referred to as the applicant, is a national of the United Republic of Tanzania who was sentenced to death for murder on 31 May 2001, as at the time of filling his application, he was at Butimba Central Prison in Mwanza up until his release following a presidential pardon of 9 December 2017. The application was filed against the United Republic of Tanzania, hereinafter referred to as the respondent state. Subject of the application, fact of the matter. It emerges from the record that on 9 February 1989, the applicant and other individuals abducted 5 people whom they took to the Lyambaka forest in the district of Kahama, claiming that they were forest guards. The applicant and his accomplices demanded money from their captives and the logging permit in exchange for their freedom. In response, the captives claimed that they had only 2,690 Tanzanian shillings. Throughout the day, the applicant and his accomplices insisted that the captives give them at least 10,000 Tanzanian shillings. In the evening, they tied up 4 of the captives, the 5th having managed to escape. The next day, that is on 10 February 1989, the escapes reported the incident to the police, who, having visited the scene, found the bullet-ridden bodies of the other 4 captives. 2 months later, that is on 2 April 1989, the escapee recognized the applicant in a shop and alerted the police, who came and arrested him. The applicant was arraigned in court and eventually convicted of murder of the 4 captives in criminal cases number 42 of 1989 before the High Court of Tanzania, sitting at Tabora. By its judgment of 31 May 2001, the High Court sentenced him to death by hanging. The applicant filed an appeal before the Court of Appeal of Tanzania, sitting at Mwanza, which by judgment of 2 July 2003, upheld the sentence handed down by the High Court. Following an initial presidential pardon, the applicant's death sentence was commuted to life imprisonment. A second presidential pardon dated on 9 December 2017 resulted in his release. Alleged violation. The applicant argues that the Court of Appeal erred in judgment of 2 July 2003 in making a significantly wide evaluation of the evidence presented by the prosecution. The applicant further contends that the respondent state violated his right to freedom from discrimination, a right to equality and equal protection of the law, the right to life and integrity of his person, a right to dignity and freedom from torture and inhuman and degrading treatment, a right to a fair trial and right to equality of people guaranteed under Article 2, 3, sub 1 and sub 2, 4, 5, 6, 7, sub 1, and 19 of the Charter, respectively. Praise of the parties. The applicant praised the court to restore justice where it has been overlooked, quash his conviction and sentence and set him at liberty, award him reparation in order to remedy the violations of his rights by the respondent state, pursuant to Article 27, sub 1 of the protocol, grant such other reliefs as the court may deem fit. Moreover, he praised the court to order the respondent state to take immediate measures to remedy the violations. In its response, the respondent state praised the court to declare that it has no jurisdiction to examine the application, declare that the application does not meet the condition of admissibility set out in Rule 40, sub 5 and 6 of the Rules of Court, declare that the respondent state has not violated the applicant's rights guaranteed in Article 3, sub 1 and 2 and 7, sub 1 of the Charter, declare that the application is inadmissible and baseless and dismiss the same, dismiss the applicant's prayers in their entirety, rule that the applicant is not entitled to reparation. On jurisdiction, the court observed that it has material, personal, temporal, and territorial jurisdiction to examine the present application and dismisses the objection to jurisdiction raised by the respondent state. On admissibility, the court, after dismissing the objection based on non-exhaustion of local remedies, find the application was not filed within a reasonable time. Operative part, for these reasons, the court unanimously on jurisdiction dismisses the objection to its jurisdiction, declares that it has jurisdiction. On admissibility, dismisses the objection based on non-exhaustion of local remedies, find that the application was not filed within a reasonable time, within the meaning of Article 56 sub 6 of the Charter and Rule 40 sub 6 of the rules, declares that the application is inadmissible. On cost, orders each party to bear its own cost. Signed by the judges, by the same judges quote above, and done at Arusha this 25th day of the September in the year 2020 in English and French, the English text being authoritative. Thank you.
And that is the judgment of the court. And I would like to congratulate Honorable Justice Bensaoula, whose first language is French, for reading the judgment in perfect English. Thank you, Judge. I now call on the registrar to read the next to indicate the next judgment that will be read.
Thank you, Honorable President. Honorable President, the next judgment to be read is judgment in application 019 of 2016, Job Mlama and others versus the United Republic of Tanzania. Thank you, sir.
Okay, thank you very much. And this next judgment will be read by Honorable Justice Angelo Matusse. Judge Matusse is with us? Yes.
Yes.
Honorable Judge Matusse, you have the floor. Thank you.
Good morning. Thank you, Mr. President. The court composed of the same bench as in the previous matter. In the matter of Job Mlama versus United Republic of Tanzania, after deliberation, renders the following judgment. The facts of the matter. The record before this court indicates that on 3 June 2008, the applicants were jointly charged with 3 counts of sexual exploitation of a child in accordance with section 138B1 of the respondent state's penal code for having allegedly forced a 13 years old girl to engage in sexual intercourse with a doctor. These counts involved threatening to use violence towards a child in order to procure sexual intercourse, knowingly keeping a child in a premise for the purpose of sexual abuse and taking advantage of a relationship with a child to procure the child for sexual intercourse. On 4 May 2009, the resident magistrate's court at Mwanza convicted all the applicants. They were each sentenced to 20 years imprisonment on the first 2 counts. Further, the third applicant was sentenced to an additional term of 15 years imprisonment on the 3rd count. The sentences were ordered to run concurrently. Dissatisfied with the conviction and sentence, on 24 June 2009, the applicants appealed to the High Court of Tanzania, sitting at Mwanza. On 26 September 2012, the High Court quashed the conviction and sentence imposed on the applicants in respect of the first count. It also quashed the conviction and sentence imposed on the 3rd applicant in respect of the 3rd count. However, the High Court confirmed the conviction and sentence of the applicants in respect of the 2nd count. Subsequently, on 15 October 2012, the applicants filed an appeal to the Court of Appeal. On 30 July 2013, the Court of Appeal dismissed the appeal in its entirety. Furthermore, it ordered each of the applicants to pay the complainant compensation of 200,000 Tanzanian shillings. Prayers of the parties. The applicant prayed the court to grant the following order: that the respondent state has violated the applicant's rights provided under Article 2 of the African Charter of Human People's Rights. B, that the respondent state has violated the applicant's rights provided under Article 3, 1, and 2 of the African Charter on Human and People's Rights. C, that the respondent state has violated the applicant's right provided under Article 7, sub 1, B, D, and Article 7, sub 2 of the African Charter on Human and People's Rights. D, that the applicant be admitted and granted in totality, the application rather, be admitted and granted in totality, that the applicant's prayers be granted, F, that the respondent be notified, seek, to quash the applicant's sentence of 20 years imprisonment per capita to restore justice. G, respondents' reparations rather to the first and second applicants in the amount of 400,000 United States dollars, each and the third applicant, 300,000 United States dollars for the violations of their rights. H, that the respondent state bears costs. The respondent state prays the court to grant the following orders: that the Honorable Court is not vested with jurisdiction to adjudicate the application, that the application has not met the admissibility requirements stipulated under Rule 40, sub 6 of the Rules of Court, that the applicant's prayers be dismissed, that the applicants continue to serve their lawful sentence, that the applicant not be granted reparations, that the application be dismissed in totality for lack of merit, that the respondent state has not violated any of the rights alleged by the applicant. The operative part. For the reasons scrutinized by the court in this matter, the court unanimously on jurisdiction dismisses the objections to its jurisdiction, declares that it has jurisdiction. On admissibility, dismisses the objections on admissibility, declares that the application is admissible. On the merits, finds that the respondent state has not violated Article 7, sub 1D of the Charter as regards the basis of the applicant's conviction being partial evidence. Finds that the respondent state has not violated Article 7, sub 2 as regards the applicant's conviction on the basis of a non-existent law. Finds that the respondent state has not violated Article 6 of the Charter as regards the denial of bail pending trial. Finds that the respondent state has not violated Articles 2 and 3 of the Charter as regards Section 138B, E of the Penal Code and the Penal Code section on morality offenses promoted sexism. On reparations, dismiss the applicant's prayer for reparation. On costs, orders each party to bear its own costs. Danet Arusha, this 25th day of September in the year 2020, in English and French, English text being authoritative. Thank you, Mr. President.
That is the judgment of the court. Thank you, Judge Angelo Matusse. Angela Matusse. Honorable judges, colleagues, parties, we are going to, the court is going to adjourn for 5 minutes to reconstitute the bench. And when we come back, we have some more judgments to read. But because it's a different bench, it is necessary that we rise to reconstitute the bench. Thank you. Julius, colleagues, I suggest